Even after an FIR is filed, the High Court has the power to cancel it. Yes, if the case is false, baseless, or an abuse of law, the High Court can quash the entire criminal proceedings under Section 528 of BNSS. In this video, I will explain a latest Supreme Court judgment that lays down clear rules for quashing FIR. Welcome to my YouTube channel, Legal Information, Law Insights. I am Advocate Mukund Mahajan. Before moving ahead, I have a humble request. You can become a member of this channel by scanning the GPay QR code and contributing 59 rupees or 119 rupees. You can cancel the membership at any time. Your small support will help spread legal awareness. Now let us move forward to the topic. Today we will discuss a very important legal power of the High Court. Quashing of FIR and criminal proceedings under Section 528 of the Bharatiya Nagarik Suraksha Sanhita, BNSS. This provision is the equivalent of former Section 482 of CRPC, which preserves the inherent powers of the High Court to prevent misuse of criminal law and to secure justice. 1. What is Section 528 BNSS? Section 528 BNSS empowers the High Court to quash FIR, quash charge sheet, quash criminal proceedings, set aside cognizance orders, prevent abuse of legal process and secure ends of justice. The provision ensures that innocent persons are not forced to face unnecessary criminal trials. The Supreme Court has repeatedly held that continuing false or baseless prosecution itself amounts to injustice. 2. When can High Court quash FIR? The High Court may quash FIR where allegations do not disclose any offense. FIR is false or motivated. Evidence clearly disproves prosecution case. Dispute is purely civil in nature. Criminal law used for harassment. Proceedings are abuse of court process. Chances of conviction are remote. 3. Landmark latest Supreme Court judgment. Case details. Case name: Sazal Bose vs. State of West Bengal and others. Citation: 2026 INSC 322. Decision date: 6th April 2026. Bench: Justice Vikram Nath, Justice Sandeep Mehta, Justice N.V. Anjaria. 4. Background of the case. FIR was registered alleging assault on a 77-year-old advocate. 5 persons were accused of forming unlawful assembly and assault. Charges included offences under IPC sections relating to assault, intimidation and damage to property. Police filed charge sheet against all accused. Accused filed petition before High Court for quashing. High Court quashed proceedings only against 2 accused. Remaining 3 accused approached the Supreme Court. 5. Evidence produced by accused. The accused produced CCTV footage, documentary material, circumstances showing false implication. The evidence suggested that allegations in FIR were vague and exaggerated. 6. Observations of the High Court. The High Court found insufficient material against 2 accused, quashed proceedings for them. However, refused to quash case against remaining 3 accused. Directed trial to continue. This resulted in partial relief. 7. Observations of the Supreme Court. The Supreme Court carefully examined FIR allegations, CCTV footage, statements of witnesses, role attributed to each accused. The court observed allegations were general and vague. No specific overt act assigned to accused. CCTV footage contradicted prosecution story. Continuing trial would cause harassment. Case appeared to be result of personal dispute. Criminal law should not be misused for vengeance. The court emphasized that unimpeachable evidence like CCTV can be considered at quashing stage. 8. Supreme Court relied on earlier judgment. The court relied on Pradeep Kumar Kesharwani vs. State of Uttar Pradesh. Criminal Appeal number 3831 of 2025. Decision date: 2nd September 2025. 9. 4-step test laid down by Supreme Court. The Supreme Court reiterated that high courts must follow these steps. 1. Check if accused has produced strong and reliable evidence. 2. Determine whether evidence clearly disproves FIR allegations. 3. Give prosecution opportunity to challenge such evidence. 4. If evidence remains unrebutted, continuing case is abuse of process. This test helps courts filter false criminal cases at early stage. 10. Supreme Court decision. The Supreme Court held. High Court committed error in not examining CCTV evidence properly. Evidence clearly contradicted prosecution allegations. No prima facie offense made out. Continuing proceedings would amount to harassment. Criminal prosecution cannot continue mechanically. Therefore, the Supreme Court quashed proceedings against remaining 3 accused also. 11. Legal principle established. The judgment clarifies. High Court can examine unimpeachable evidence at quashing stage. Trial should not continue when innocence is clear. Courts must prevent abuse of criminal process. Section 528 BNSS must be used to secure justice. 12. Practical example. If a person is falsely implicated. Business dispute converted into cheating case. Family dispute converted into assault case. Political rivalry converted into criminal complaint. He can approach High Court under Section 528 BNSS. 13. Future impact of this judgment. This decision will strengthen protection of innocent persons, reduce false criminal prosecutions, encourage early quashing of weak cases, save judicial time, prevent harassment through criminal law, guide high courts to examine electronic evidence. The judgment also confirms that Section 528 BNSS is a powerful safeguard against misuse of criminal law. 14. Key takeaways. High Court has inherent power under Section 528 BNSS. FIR can be quashed if false or baseless. Strong evidence like CCTV can be considered. Courts must prevent abuse of process. Trial should not continue unnecessarily. Justice requires early intervention. 15. Conclusion. The Supreme Court has made it clear. When irrefutable evidence shows innocence, high courts must use their inherent powers under Section 528 BNSS to quash FIR and criminal proceedings and prevent misuse of criminal law. This ensures justice, fairness, and protection of innocent citizens. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind. Jai Bharat.